I'm Matt Guichard, and this is No Holds Barred. We're pleased today to have Justin Sonniksen back, helping us understand in this episode the benefits that particularly accrue to workers in the workers' compensation system. So welcome back, Justin.
Thank you.
It's good to have you back again, and there's so many questions that have come up since you were here last time in discussing workers' compensation. So today particularly I want to focus on workers' benefits.
Okay.
So we've talked about a lot of other things, but really, what does a worker get? What are the terms that are used, and what does a worker get when a worker's injured on the job and falls within the workers' compensation system?
Nearly all of my clients, when they get injured, say, what about my pain and suffering? And I say, well, you get pain and suffering, you just don't get any money for it, workers' comp. It's very limited, but you get plenty of pain and suffering. So there's 5 benefits that are recognized under the labor code that you can get if you get injured at work. The big one historically has been medical treatment. Medical treatment at no cost to the worker. The theory when workers' compensation developed is we want to give rapid treatment to workers with injuries, get them back into the labor force at no cost to them. Even if the vast majority of the need for treatment is due to non-work related issues, we want the worker to bear no cost to get medical to get back to work, because many of them cannot afford medical if they had to pay their relative share. Mm-hmm. So even if the injury is only 1% work related, the employer has to pay for all the medical care for that medical condition. So that's the first one, that's the big one. Temporary disability, you get 2/3 of your gross salary while you're off work recovering for an injury. And there's a statutory limit. I think the current statutory limit's $1,539 a week is the maximum temporary disability. So if you're an earner that makes over $125,000 a year, you get capped on what you can get for temporary disability benefits. Mm-hmm. And there's a minimum too. I think the minimum is $220, something like that, per week. So even if you made less than that, there's a statutory minimum.
I see.
You can get that benefit for a maximum of 104 weeks within a period of 5 years from the date of the injury. There's certain very limited exceptions. So like one of the exceptions to that limit is a high velocity eye injury. It obviously rarely happens, but if you suffer a high velocity eye injury, you can get temporary disability for up to 240 weeks within a period of 5 years. Another exception is serious burns, chronic lung disease. There's certain strange exceptions to that rule. Mm-hmm. But the general rule is it's 104 weeks within a period of 5 years from the date of injury while you're recovering off work. The theory behind temporary disability is the worker's unable to earn wages while he or she is recovering from their treatment for the injury. They have restrictions. They can't be accommodated by their employer, so they're off work. And then they're entitled to temporary disability benefits while they're recovering from the injury. Mm-hmm. So it's not wage loss in the personal injury sense. It's just a temporary benefit while they're, in theory, treating for the work injury. And then the big one in terms of the fight between the lawyers is permanent disability. So you get permanent disability once your injury stabilizes. You've reached a plateau medically. You're not going to get any better or worse with or without treatment for the next year. You've reached a plateau. It's called permanent and stationary, or maximum medical improvement. So once you're at that point, you get a percentage of permanent disability for your injury. Then you're rated on a scale of 0 to 100% disabled. And it's set by law how much you get. It doesn't really matter how much you earned at the time of the injury in terms of it's not wage loss, it's not future wage loss replacement. The rate is $290 per week. Well, that's the maximum rate. Some people get less than that, but the maximum rate is $290 a week for permanent disability. And they don't necessarily factor in, hey, he lost his job, he was making $80,000 a year, we should compensate him for that. That's not how it works. It's set by law. There's a schedule, and every percentage of disability has a corresponding dollar amount. Mm-hmm. And so the query is, how disabled are you? Where do you fit on that scale of 0 to 100%? And that determines the extent of your permanent disability benefits. And the current rate is $290 a week. So it's not very much money. I always tell my clients, the goal is to try to get back to work because if you lose your job because of this injury, the law does not do a good job compensating you for your loss of future income. So it's a very limited monetary benefit. Again, the exchange is not having to prove fault or having to go through all the litigation you do in a personal injury case. The other benefit is death benefits. So if you're injured at work and it results in your death, your dependents can collect benefits for that. Death benefits cause a lot of litigation because, number one, you have to establish dependency. There's certain categories of people who are presumed to be totally dependent on the worker. Most of the times you're getting into issues of partial dependency. And then you have to figure out how financially dependent was this person on the injured worker when he or she died. And there's the labor code sets forth certain classes of people who can be partially dependent. So, one example is they lived with the worker at the time of death, or they're a child or a parent, or there are certain familial relationships that the labor code recognizes that someone can be a dependent. It doesn't go to your estate. It doesn't go through probate. Workers' comp benefits, to get death benefits, you have to be a partial or total dependent of the worker who died. And if you die without any financial dependence, then the state of California has a death without dependence fund, and the employer has to pay that entity, I think it's $250,000. So a lot of times it's a weird situation where the employer wants to find they're on the same team as the injured worker's attorney because they want to find a partial dependent because oftentimes that payout is far less than $250,000. So that's the fourth one. And the last one is a supplemental job retraining voucher benefit. So if you sustain permanent disability because of an injury, and let's say you have work restrictions and the employer cannot accommodate those restrictions, they can't bring you back to a modified job or your old job, then they have to give you a job retraining voucher. It's very limited. It's only $6,000 of training plus a $5,000 cash payment from the state of California. Again, if you have permanent disability from the injury and the employer is unable to accommodate you with a modified job or your old job, then the employer has to pay you a job retraining voucher. We used to have vocational rehabilitation, but that was repealed back in 2009. So, and then that's it. Those are the 5 benefits you can qualify for in workers' compensation when you have an injury at work.
Well, I wish that was it, but because the 5 that you've talked about raise so many issues that I think that people would be very interested to hear from. So let's just start out with, you used that term several times, accommodation. What does that mean? Does that mean that when you say either the employer can't accommodate somebody, or does that contemplate that the employer would put somebody over at a desk and have them count thumbtacks or do something and continue to get paid? What does that mean?
And this actually is a good thing to bring up, just to clarify. So when we talk about disability accommodation, it's important to recognize workers' compensation is separate from employment law, because a lot of my clients ask me employment law related questions under the FEHA statute, and we don't do employment law. We deal with workers' compensation, so it's actually different than employment law. Employment law is, the employer discriminates against you, let's say for a disability that you have. That's not what the Workers' Compensation Board does. The Workers' Comp Board deals with paying benefits owed by the employer's insurance company for an injury. So getting into accommodation issues, there's a little bit of overlap there because the employer's ability to accommodate an injured worker determines whether the insurance company owes the worker a job voucher. So let's say the worker is off on temporary disability and then the doctor says he or she's reached a point where they've stabilized. They're as good as they're going to get. And they have X, Y, and Z in terms of restrictions. So then the employer has to sit down and figure out, all right, can we accommodate this person? Can we bring them back within these restrictions? Can they do their old job within these restrictions? Is it congruent with what they were doing before? And they have a time frame to bring them back to work to make a formal offer within those restrictions. If they do so, then that alleviates their liability to provide the job retraining voucher. But it really doesn't have much relevance in terms of the permanent disability money. That's what a lot of my clients get frustrated by. They're like, well, I lost my job, so I must get more money, but one doesn't necessarily lead to the other. The permanent disability is just based on where do you fit on that scale. But in terms of accommodation, the Workers' Comp Board doesn't really get into like reasonable accommodation, interactive process issues, that's more employment law. It's a very simplistic approach. Did the employer accommodate their restrictions on time that the doctor gave the worker? If they did, then they don't owe the job voucher. If they did not, then they have to provide the voucher to the worker.
I see. So if somebody comes to you and wants to get into employment issues, you refer them off to an employment lawyer.
Absolutely.
After listening to him. Let me ask a little, we often hear about the issue of somebody on light duty, so that somebody works, they are injured in some fashion, and we hear they're doing light duty. Or oftentimes with police officers, they're no longer out on patrol, they're doing desk duty, which sounds like something having to do with accommodation.
Yeah, so it's, a lot of my clients, it's funny when I tell them that we don't really have much to do with your employer. They're like, well, I got hurt at work, it's workers' compensation, but it's actually very different. We don't get into the accommodation issues, because they'll say, well, this is not inappropriate pursuant to the contract. This isn't the job I'm supposed to be doing. But the workers' comp board just looks at, did the employer give you light duty? Let's say you have an injury, the doctor gives you temporary work restrictions. The employer can avoid having to pay temporary disability benefits if they put them on light duty, as you put it. So if the, particularly larger employer, if they have job duties that are consistent with what the doctor is saying the person should avoid doing, then they don't have to pay temporary disability benefits to the worker. So, we do get into that issue a little bit at the comp board, only to the extent of, does the insurance company have to pay temporary disability to the worker?
I get it. That raises a very big question. Now, we've kind of skirted a little bit. When does an injured worker need an attorney?
So that's a good question. I don't want to sound self-serving, but so I'll try to answer
You can be self-serving.
as objectively as possible. Most injuries, I would say, someone gets injured at work, they go to the company clinic for treatment for a few weeks, they go back to work, they go on with their lives. That's what most injuries are. I would say, reasons to get an attorney are, if you've been off work for an extended period of time, that portends to lead to a situation where you're probably going to have some permanent disability at the end. If the insurance company is denying your medical treatment request from your doctor, that's a reason to contact an attorney to see if he or she can help you with, did they deny it properly? Can we appeal the denials of care, things of that nature? That would be a reason. If the insurance company wants you to see a qualified medical examiner, that's an independent doctor that evaluates your injury. They don't provide treatment. They evaluate the worker, and then they place them on that scale, that 0 to 100% scale. If the insurance company is pushing you to get to see a qualified medical examiner, that's a reason to consult with a lawyer, because the insurance company, oftentimes they set up the QME, and they find specialties of doctors that are employer friendly. And so if you hire an attorney, usually the attorney can help you get a more patient-friendly doctor, or the attorney can reach an agreement with the insurance company on an agreed evaluator, which is usually what the workers' comp board likes to see, both parties agreeing on a doctor.
I see.
A worker, unrepresented, cannot agree with the insurance company on an independent evaluator. So only if you're represented by an attorney. One extreme example is if the insurance company gets an attorney and they start pestering you, you definitely need to get an attorney. I've had clients that, I can't believe they did this, but the insurance company, the worker was off work for a while. The insurance company hires an attorney, and the attorney, the insurance company attorney can file an application with the workers' comp board to give the board jurisdiction. It doesn't have to be from the worker side. The insurance company can. They can vest the board with jurisdiction over the claim. So once the board has jurisdiction, then you can do discovery, take depositions, what have you. And I've had situations where my clients were unrepresented. The insurance company hired an attorney. They filed the application with the workers' comp board, and that gave the board jurisdiction over the claim. They took my client's deposition. They didn't get a lawyer. I mean, why you would go to a deposition without a lawyer is beyond me. And then you get the transcript, and the attorney's asking all kinds of inappropriate questions that are beyond the scope of what should be asked.
They can't object or don't know to object.
They don't know to object. They didn't have an attorney. And the good thing about workers' comp is you don't pay any money out of your pocket to hire a lawyer. There's no financial risk to hiring one. Our contingency fee rate is relatively low. It's 15% instead of a third, like in a personal injury, because we have less risk. We front less costs, and so our contingency fee rate is a lot lower. It's 15%.
Wow.
And obviously, we don't get a recovery unless the worker does. And our main source of recovery is at the end of the case out of the permanent disability. And if we settle out the medical treatment award, it's the same contingency fee for that. But there's really no financial risk. At no point does the injured worker have to pay their attorney out of pocket.
I see.
So it's always beneficial to at least consult with one because it doesn't cost anything. We can't charge our client, even if the client agreed to, we can't charge them out of pocket. The board doesn't allow it. So
the moral of that story is absolutely consult with an attorney. I've often seen situations where somebody is injured on the job, goes home, calls in sick for a couple of days, uses their own medical benefits to go be treated at a emergency room or urgent care, and builds up a pretty significant initial medical bill, and then somebody tells them, well, you were injured on the job, this is a comp benefit. So one case that we had like that, there was kind of a dispute by the employer as to whether or not the person was actually injured on the job, and there was a big fight about who's going to pay that big bill. But it seems to me, right from the start, get a hold of Justin Sonniksen, and hey, I need to chat with you. I was injured on the job. I mean, isn't that really the way to go? Self-serving or not, that makes complete sense.
And a lot of times clients will come in and we'll do a meeting, and I don't, for whatever reason, whether they don't want to or I don't want to represent them, we don't take on the representation, but I still give them advice about here's what to do, X, Y, and Z about protecting your rights. But yeah, that would be a situation where you definitely want to consult with an attorney, because the sooner you file the claim, the better. And the employer is supposed to pay for your medical treatment for the injury. So you're not supposed to, if it's a legitimate workers' compensation injury, you're not supposed to be accumulating medical debt because of that injury. It's supposed to be at no cost. So,
how would that work though, when you think that, let's say someone works for an employer and the employer provides medical insurance, that injured worker is injured, takes advantage of their employee medical insurance, which is actually paid by the employer,
right?
And then it turns out it's a workers' comp case. Does one side or the other get a benefit? Is that other insurance company, the medical insurance company, reimbursed, or how does that work?
So they have the employee's personal health insurance, even if it's provided by the employer, can file a lien claim in the workers' compensation case to get a recovery for the medical they provided to the worker for a work-related injury, because the employer has group health, let's say, but they also have to have separate workers' compensation insurance. And so you get into a lot of fights of who has to pay for this. So in theory, there's a law that says a medical provider cannot go after a worker personally for medical treatment bills if it's an accepted workers' compensation injury. It's actually in the labor code that it's a penalty for them to do that. So their remedy is they being the insurance company, the remedy is to file a lien in the workers' compensation at the Workers' Compensation Appeals Board, and then the workers' compensation insurance company is supposed to address their lien claim for the medical that they provided to the worker.
I see. So that's important, I think, for our audience to understand, and particularly employers, is that just because you provide an employer-based health plan does not mean that you don't have to have workers' comp, because they're two completely separate systems, and the requirement of the employer to have workers' compensation system has nothing to do with the fact that they may have an employer-based health plan.
That's absolutely correct. That's right. That you providing health insurance to your employees doesn't alleviate your responsibility to have workers' comp coverage. So, and if our clients are getting bills from insurance providers or medical providers for workers' comp treatment, our office puts them on notice. Hey, this is a workers' comp case. You need to bill XYZ insurance company don't come after the client because it's illegal under the labor code to do that.
How about for the client that, for example, goes to, you often think, walk into an emergency room, and according to their health plan, it's paid by the health plan, but there's a $300 deductible. So they walk in, they've got to pay out of their own pocket, and they actually do pay out of their own pocket, say that $300. Then their insurance company, employer-based, pays for the MRIs and all that, and all of a sudden you have a bill for $30,000, but some of which is out of the pocket of the employee. So the same thing as the workers' comp lawyer would put a lien.
So let's say the worker in that situation, it's a legitimate emergency, and it's legitimately for the work injury, and they had to go to the ER, and it's clear that this was for the work injury. So in that instance, the worker wouldn't file a lien. We just directly request reimbursement for that $300 from the insurance company as a reasonable medically self-procured medical expense. So that wouldn't, because the lien is a recovery in the case, so this is an out-of-pocket expenditure by the worker that should be paid directly by the workers' comp insurance company. Again, if it's a legitimate emergency connected to the workers' comp injury, because in workers' comp, the general rule is you have to go through what the insurance company's medical provider network. So they have a network of doctors. You have to pick a doctor off their list, and that's where you're supposed to get your treatment for the work injury. And the general rule is any treatment outside of that medical provider network is not the workers' comp insurance company's responsibility. But in a situation like that where there was an emergency and you could show it's due to the work injury, then they would the board would order reimbursement to the worker for that $300.
One more reason to have a workers' comp lawyer to know these things when you get injured.
Oh, absolutely. Yeah. It's a very complex system, and it's very, very heavily regulated and statutory. And the law is constantly changing. It's hard for us to know everything as attorneys. And I've been doing this 19 years, and I learn something every week, it seems. So they've created the system where it's almost impossible to navigate on your own, because the insurance company, they know all the rules, they know all the ins and outs, and so you as a worker, you're really at a disadvantage if you go at it on alone. Again, assuming a case where you're off work for an extended period of time, or you have some serious, that there's going to be some serious permanent damage due to this injury, you're really at a huge disadvantage. I would say 9 times out of 10, when my clients come into the office, I know that I can make their situation better than if they're on their own. And if I can't, then I just decline the case. So.
But consult with them. So I think the employee, people listening in, should absolutely consult with a lawyer. It just seems without question to.
There's really no risk, because
yeah.
it's a free consultation, and if you don't want to hire the attorney, you're
free not to.
I'm not selling timeshares.
Yeah.
You're free to.
Got it.
Free to walk out the door.
Let's talk about the issue of statute of limitations. It comes up in the law all the time, and kind of that scenario that I was talking before, let's just use it a little different as a hypothetical, is that a person gets injured on the job but doesn't think about that this is a job injury, doesn't really understand, goes to the emergency room, incurs a lot of health care, and then things are kind of okay for a period of time, but let's say 6 or 8 months later, steps off a curb, and that back injury from way back when now really manifests itself, and the worker then talks to a workers' comp lawyer and realizes, holy mackerel, this is a workers' comp case, should have been a long time ago. What is the statute of limitations? How long can that take?
All right, so I'll start by saying this. In workers' compensation, the statute of limitations is a disfavored defense. I know in a lot of the civil arena, it can be pretty harsh, pretty strict. I will say this, the workers' comp board tries to go out of its way not to bar claims based on the statute of limitations. But the general rule is you have 1 year to file an injury if it's a specific event, you have to file the claim. Well, you're supposed to file the claim within 30 days of that event. That's what the labor code says. However, you're allowed to file an application with the workers' comp board. That's the workers' comp board has jurisdiction over work injuries. You have 1 year from the date of the injury to file with the workers' comp board. So the general rule is for a specific injurious event, it's 1 year from the date of the injury. Now, it gets complex, because if the employer is put on notice of the injury, the employer's obligation is to provide the worker with a claim form. And so the onus is on the employer when they obtain knowledge of the injury from any source that they have to give the worker their notice of their rights to file workers' comp. So if they fail to do so, that tolls the statute. So it's not as harsh of a 1-year statute in workers' comp if the employer doesn't give them notice of their rights to file a claim. If the employer gives them the right to file the claim and they don't do so, then their claim can be time barred.
Mm-hmm.
So the general rule is 1 year from the injury, but it can be extended if the employer doesn't put them on notice of their right to file a claim. You know, it can be the employer saying, hey, Joe said that you got injured here the other day. Here's a claim form. Do you want to file a claim? That's when the clock starts ticking. So
I see.
it also gets tricky for what's called cumulative trauma injury claims. So those are injuries that occur over time, not on just one day. California is one of the few states that recognizes cumulative trauma injuries. So just the repetitive nature of the job over time, your hands, your back, your knee goes out because of the wear and tear of the job. Those types of injuries have a unique statute of limitations. So it's 1 year from when the worker knew or should have known that they have a work injury and suffered disability from that injury, whether it's in the need for ongoing medical care or need to be off work or some sort of cognizable disability, like they can't do their job the way they used to. So for cumulative trauma, it can extend out for years. I had a case where a firefighter worked for the city of San Francisco back in the 80s and 90s and what have you. He last worked there in the year 2000. And about 18 years after his last day at work, he found out he had developed cancer. And so he went to the doctor, and the doctor said, you have cancer. And unfortunately, it was terminal, so we filed a claim for death benefits in connection with his employment as a firefighter, even though he hadn't worked there for 18 years. And the reason we were able to do that and prosecute that case is that he didn't know that we were able to establish that the work itself actually contributed to his mm-hmm. cancer. Mm-hmm. Again, the threshold in workers' comp is very low. It's only it's 1%. If you can show just a tiny bit of this work exposure led to the condition, then you're in the workers' comp system for medical treatment or disability. So in any event, we were able to establish, the doctor agreed that his work as a firefighter was causative, at least in part, of his cancer. And he wasn't on notice of that until he saw the doctor in 2018. So when he became on notice of that, he had 1 year from that point to file his claim. We filed the claim on time, and he was able to get his dependents were able to get workers' compensation death benefits, even though he hadn't worked there in 18 years.
I
see. For cumulative trauma injuries, the statute of limitations is different than for specific mm-hmm. injuries. Mm-hmm.
But I see this whole system is, as you said when we started out in episode 1, is designed to help the worker and protect workers. That then brings up when you're talking about percentages, and so I'm thinking of the firefighter over time, and often with firefighters, cancer is per se job-related even 18 years later.
Yeah, there's a statute for peace officers and firefighters where it's presumed that certain cancer or certain types of heart trouble are work-related. Mm-hmm. Because there's so much controversy in medical literature over causation in terms of whether these exposures lead to cancer or heart conditions, what have you. And what the legislature did is took it out of that arena and just said if you're a peace officer for X number of years or a firefighter, actively employed firefighter, and you develop cancer or heart trouble, again, it's within a certain period of time after you stop working, it's presumed to be work-related, and it's a very hard presumption to overcome. It's not conclusive, but it's fairly close to the conclusive presumption. Mm-hmm. Mm-hmm. Now, in our case, he hadn't worked there in 18 years, so that was beyond the presumption time. The presumption extends out, I think it's 10 years at most, mm-hmm. For peace officers and firefighters. So we were beyond the legal presumed time period for it to be presumed by law to be work-related. But, yeah. But medically, we were able to establish that it was.
Well, we're talking about benefits, and I think we're going to kind of wrap it up, but I do want very much to understand those percentages that you're talking about. And I'll just say from some cases that we ran into where somebody there was a percentage already from a prior injury years ago.
Okay.
So they were ex-disabled, and then they incurred on that job another injury. It was a police officer, actually, another injury, different part of the body.
Mm-hmm.
And then a number of years later, involved in a third-party case while they were working, driving that car.
Okay.
So how do you, I'll use that term apportion, I think that might be the term that you, how do you apportion those various things, and what would be the benefit that worker would be entitled to given those prior disabilities?
Okay, so apportionment is a very controversial concept in workers' compensation. So it's an allocation of responsibility for this injury. So determining what was caused by this injury versus what was caused by prior injuries or non-work-related medical conditions. So there's two types of apportionment. There's medical-based apportionment and there's legal apportionment. So let's start with your example. Injured worker has an injury to the knee, and he's deemed 10% permanently disabled because of the knee injury to the right knee. So under the law, it's presumed that that disability is presumed to exist at the time of any subsequent injury to that knee. So in other words, he gets a new injury to the same knee 10 years later. And now, I'm making this overly simplistic, but let's say now his overall disability in the knee is 30%. And as long as the employer establishes that those disabilities overlap, in other words, the same factors that led to the old knee disability are still present now, then you take the 30% and you subtract 10, and that worker receives a 20% disability for the second injury. So you subtract out the prior percentage, as long as you've established that it's the same body part and there's some overlap between the two disabilities. So it reduces the benefits that the worker gets on the second injury because the employer gets credit for his previously received 10% permanent disability award.
But the employee has already gotten the benefit of the 10%.
Correct.
So presumably under the system, the employee has been taking care of 10%. This time it's allocated at 30, but 20% of it is the new one, so he gets 20%. So that seems fair. Am I?
The only caveat I would point out is that the permanent disability schedule is it's not linear. It accelerates the more disabled you are. So 5% and 5% is worth less than 10%, for example. So the higher the disability goes, it accelerates the payments. Mm-hmm. So you get a lot less money if you have two 10% awards than if you have a 20% award. So it actually inures more heavily towards the employer. But in 2004, they overhauled the workers' comp system to really kind of reduce permanent disability benefits, especially in the context of prior injuries. So the worker gets a lot less money if they have two injuries than if they have one, which on its face doesn't seem logical, but that's the way the law is written. So,
well, let's say it's that same scenario. However, it was the right knee 10%, and the new injury is the left knee 50%. Mm-hmm. So you're talking 60% disabled. How does that work?
Okay, so let's say old injury was to the right knee, 10%, and now we have a new injury to the left knee is 50%. The doctor looks at this left knee and says, well, none of this was due to the old right knee injury, so we're going to say it's all due to this new injury to the left knee. So the worker gets 50% disability for that injury. But there's a statute, Labor Code Section 4664, that cautions that a worker cannot receive more than 100% accumulated disabilities to one region of the body over their lifetime. So once they've gotten that 10%, and now they have this new injury that's 50%, they're at 60% overall. So any future injuries, the cap for the lower extremities will be, at most, they could get 40%. because you can't be more than 100% in any region of the body over the course of your lifetime. So now the other kind of apportionment is the doctor could say, all right, we have this left knee, it's 50% disabled. It's got nothing to do with his old right knee injury, so we're not going to apportion anything out to that. But we looked at his MRI after the injury, and he looks like he had some degeneration in there that's completely not work-related. So I think that 20% of his disability in the left knee is due to that non-work-related medical condition. And so that's the way the employer gets to reduce their liability for the left knee. You take 80% of 50, and so the worker would get a 40% disability rating instead of a 50 because of a non-work-related medical condition that the doctor identified was causing some of their disability. Mm-hmm. So there's two different ways the employer can reduce its liability under that theory of apportionment. I'm sorry, real quickly.
Yeah.
Even if the worker wasn't having any problems with the left knee before, so it can be rather harsh.
I see. Well, let's assume that we've got the 10% and we've got the, we'll call it 50% or whatever in the other knee. But with the 10%, the person is, they haven't reached the point of permanent and stable, so they haven't reached an agreement on future payment. And the worker's concerned about, wait, I don't want to jeopardize my payment on my right knee because of this new injury. I mean, I want to make sure they're separate. And we've heard that before. Somebody said, well, wait a minute, I'm getting benefits. I don't want to jeopardize those with this new injury. How's that work?
So you wouldn't get the 10% rating on the one knee until you are stable.
I see.
You won't get your disability award until the doctor says you're as good as you're going to get, you're permanent and stationary, and that's the point where they figure out, all right, where do you fit on that scale? And there's a lot of things that to get to that 10%, they look at your impairment, the type of job you did, and the age you did, the age you were on the date of the injury. All that factors into how we get to that final number. So once you wouldn't get the 10% rating until you are stable on that knee injury claim. So the only way it would affect a new injury is if, I guess in theory, if you're still being paid out, because permanent disability is paid in installments. It's paid at maximum $290 per week until the award is paid out in full. It's typically not in a lump sum. So the only way they would have any impact is if he was still collecting benefits from the employer on an old injury, and then had a new injury where he was off work. But even then, in theory, you would still get 2/3 of your because if it's a new injury, you'd still get 2/3 of your salary while you're off work. So that would be an instance where you could get both.
I see. What I often hear about, though, is a payoff. So somebody comes, you've got that 10%, you've been injured, it's only 10%, you're working, and you got temporary disability. They talk about permanent disability, but it appears that they compromise. They kind of say, okay, I'll take a lump sum now, we'll call it a day. How's that work?
All right, so typically employers don't do this if the employee is still working at the employer. The theory being that we give them all this money for not only the disability but their future medical care. Well, if they're still working at the employer, then that hasn't bought them anything in terms of finality, because right after they settle the case, they could re-injure the same body part, and then the employer's on the hook again for temporary disability and medical and all the benefits that you get in workers' comp. So, but let's say you have an injury where the worker no longer works for the employer, and they have let's say 10% disability on the knee. But the doctor says, this guy in the future is probably going to need knee surgery, so that should be part of his future medical care plan. Well, the insurance company for the employer can reach out to the worker and say, we'll give you $30,000 or whatever to close out your medical treatment rights for that body part. So that way they get all their disability in a lump sum instead of installments, and then they get a cash payout for the medical treatment in the future. And there's other things that you buy out too, because you have 5 years to reopen your case. So let's say you get an injury and it results in 10% disability, and the injury is 2 years old when you reach that settlement. Well, if your knee injury gets worse within the next 3 years or 5 years from the date of the injury, the board has the ability to reopen the case and reconsider the award and award a higher level of disability for the knee because of the natural progression of the injury. The guy needed surgery again or what have you. And so that 10% isn't necessarily the final number you get. So that's another thing you can buy out and close out if you do a lump sum settlement, which they call a compromise and release.
Yes, sir.
So it closes out that liability, and it also closes out your right to pursue death benefits. So, let's take an extreme example. Let's say you have a 10% knee injury, and the worker has an ongoing medical award, and then he goes to have surgery on that knee and dies as a result of the surgery. Well, as long as it's within a period of 240 weeks from the date of the injury, that worker's dependents can get death benefits because he died getting medical treatment for the injury. So there's a lot of things that the insurance company can buy out with a full compromise and release. And our clients like it because they get all their money at once instead of installments of $290 a week. And also, you obviously get a lot more money when you settle out your rights to future medical care. So,
Gotcha. So again, I'm going to repeat, the moral of the story is get a workers' compensation lawyer if you're an injured employee, and even an employer, you want to make sure that things are all done right within that system.
yeah, it's a very complicated system, and like I said, there's no cost to at least getting a consultation if you have questions. So,
Gotcha. All right, well, thank you very much. This concludes this episode of No Holds Barred, and we look forward to seeing you on our next episode.